When Good morning, good afternoon, good evening, good part of day, everyone. Thank you for joining us at the largest, fastest growing, and the most active global community called our Organizational Design, Product Centricity, Customer Focus, aka Large Scale Scrum. Today we have a very special guest in the house, Brett Frazer. Brett is a partner with the Howley Truxwell and is the chair of the firm's intellectual property and internet practice group. Brett emphasizes and focuses on all facets of internet law, intellectual property law, and information technology law. Brett also helps clients with related transactional work and litigation. He is also a very well-known published novelist, and he has also written extensively for national legal publications and law blogs. He's also a frequent speaker on internet, intellectual property, and computer law topics. In 1997, he accepted his in-house position as a senior intellectual property counsel with the Fortune 1000 company, Micron Electronics, and remained there through the company's merger with Interland later on. The nation's largest web hosting company that has become. Brett has eventually become Deputy General Counsel for Micron Electronics. Today he is one of the leaders in the industry who spearheads uh, topics and discussions that have to do with internet law, IP, and IT laws. His co-presenter, his co-partner, wing person today is Richard Hundhausen, my good friend, whom I known for many years. He's the president of the company called Ascentian, a company that helps software teams deliver better products by understanding and leveraging Scrum and DevOps. Richard is one of the certified professional Scrum trainers and the author of Professional Scrum Development with Microsoft Visual Studio. He is also one of the co-creators of Nexus Scale Framework that's very friendly and very consistent and complementary on many fronts with our large scale Scrum, the meetup of which we are being a part of today. So without any further ado, I would like to pass the baton over to Brad and Richard helping him along. So thank you very much for being here both.
Thank you,
Thanks,
Chief.
Gene. So what we're going to do is I'm going to kick things off from a complete techie point of view, and then eventually hand it over to Brad, who's going to stop me in my tracks and explain a few things to me and thus you on some of the pitfalls, risks, and things to think about in what I just did. So first of all, let me share my screen, make sure you can all see that. Um, Thanks for the intro, Gene. Nothing really to add there. Just you know, there's email. I'm pretty active on LinkedIn. Maybe not as much as some out there, but you'll see I'm tagging more and more hashtag Who owns the code as I'm jumping into other people on LinkedIn. Talking about how great and how fast they can build products using AI. So what I'm going to do, I'm going to jump right into it. I got Chat GPT all warmed up here. I got the new model. Yeah, I know there's the thinking, deeper research. I'm a fan of the fast. I don't know about you, but usually the fast answers from chat are good enough for me. So here I am. I'm going to make $1 million in about 10 minutes. So I think I'm going to come in here and say, I want to create a software app for the classic Battleship board game. And you can chat banty back and forth. Okay, well, what are you, single player platform? Are we going to do multiplayer here? Um, I want to support one player versus computer, um, thinking web-based. How big is my market? I'm just going to do a couple little product management things here. I think a lot of you are Scrum people, so you probably appreciate, good, empowered product owners out there getting intel however they can. I don't want to ever suggest not talking to people, instead talking to computers, but you can get an idea here. Um, who might the personas be? So I'm just kind of spitballing the nostalgic player, 30 to 55 years old. And you can have this build actual personas with pseudonames and even have it sketch some art for you so that you can kind of, have your four different personas here you're going to target. Um, I might say what would be a good product vision, series of product goals, and one to start with. So again, I'm kind of going through professional Scrum, product ownership here. Here's a vision, here's some different product goals, you know, deliver a working battleship game against basic AI. So maybe start with the MVP core playability loop. Okay, so now I'm going to switch over to GitHub Copilot inside of VS Code. What prompt should I give it to scaffold the project and build the MVP? I mean, I'm super lazy here. I don't even want to, you know, file new workspace. I don't want to do any of that. So, here it is. It's given me the the actual prompt to use. So I'm just gonna, and I don't know why sometimes it says this is VB.net. I don't know where it gets the language that it's always wrong. So I'm gonna copy this. I'm gonna switch over to Visual Studio Code, latest version. I do have a Copilot license here. I've got my chat going. Let me just minimize this, probably in the way. So what I'm going to do here is just put it in the chat window here. Control V, paste in the whole prompt. I'm in agentic mode, so it should be able to, operate Visual Studio Code for me. And working. This is taking forever. I could have hand coded this so much faster. Now I have to wait seconds for this thing to build it for me. But the $1 million, whether it comes in an hour or an hour and 10 minutes, I can handle either one. I can be patient. So let's see. It's got a folder here. Some files should start appearing. Okay, good. We've got some packages coming in. Here's my source. I got a couple files. There's my style sheet. And I'm expecting this to be perfect, like absolutely, the exact way I would have built it without having to do any work, because that's AI, right? Everything I read is how much better programmer I can be, this Vibe 10x programmer by using GitHub Copilot. So I don't know, are you done? To run the app? Okay, it even tells me how to run the app. Open a terminal, do an npm install. Pretty sure I already have that. Let's open localhost. Let me get my npm start here. Yeah, owner of the agentic will just open the terminal window for me. Can I be that lazy? Yes, I can. Okay. And then I'm just gonna, now I'm gonna say, what do I type in the window? Because again, I don't want to do too much work for this $1 million. npm install. All right, error, whatever. npm run. I thought I already had it installed, but okay. So, again, I'm doing this real world. I'm just gonna paste all this back in here and let it figure it out. I'm in the wrong directory. Okay, so need to be in the Battleship React directory where my what is? Package JSON. Okay, so change to that directory for me. Continue. Look at that. So I can just be so lazy here. npm install. Sorry, Brad. This will just take a second, and then you can.
No, this is good, Rich. Take your time.
Oh, see, it's giving me deprecated things. But I don't care. I'm going to just see if I can start this. And I'm going to allow that. And let's just go over here. Of course, it's telling me that there's an error. So again, I'm gonna give this just a few more moments here, see if we can't get this fixed. Is running, but you haven't built or started the React. Okay, I did do that. I'm in the React directory. What's my error? Oh, I'm just gonna take all this and let it figure it out. Dang, this $1 million is getting harder and harder to yeah, do that for me. And why didn't you do it in the first place? Come on, AI is so useless. Okay, so let's run it now. First, I want to make sure I got that one. Okay, now let's do an npm start. All right. Well, I can go around a bit more with the editor, and I can get this thing up, and it would be like super awesome web-based battleship game playing against the AI. But I'll get that done tonight. And in the meantime, though, I want to start talking about selling my product, selling my company, exiting. So I'm going to go out and find some counsel. So I watched this thing on YouTube, and Brad's name came up. So hi, Brad. I'm Richard. I built this product using AI. I've done almost zero human uh, creation, and I'm hoping you can tell me how to make $1 million with it.
Richard, hi, good to meet you. So that sounds great. You know, Richard, over the last 37 years, as I've been a copyright lawyer and a copyright litigator and an IT lawyer, what you've described, Richard, is exactly what I've helped, maybe not hundreds, but a lot of people do, which is take an idea and encapsulate it or build intellectual property schemas around it, and then raise money and have an exit. I've done it again and again and again. So I think, not to be trite, you've come to the right guy, because we can take your $1 million idea, Rich, and we can build a company and we can have an exit. And you bet we can. Initially, though, Rich, what are you going to do with that battleship game? Are you going to put it up on the App Store? Are you going to put it on whoownsthecode.com? Where are you going to allow people to download and play that game? And how much are you going to charge them to do that?
So I know not to put it on GitHub because then that makes it open source, if I remember correctly. So we're going to probably arrange some servers in AWS and let some people play for free. But eventually, it'll pop up and ask them for their credit card. I'm going to build that module tonight.
Okay. So Rich, you do intend to monetize this battleship game.
Oh yeah, that's
Okay.
right.
And how many years do you think you'll have before you exit and get your $1 million exit from your battleship unicorn?
I was thinking, well, let's see, Monday's a holiday, so I was thinking Tuesday works for me.
Okay, that sounds great. Let's plan on getting our $1 million exit on Tuesday.
Okay.
At some point, Rich, when you go to exit with your battleship game intellectual property, a buyer or an investor or a bank, they're all the same in this context, is going to ask you some questions. And I don't know how many of our audience have actually exited from a startup. But during that process, or you've done a Series A round, or you've gone out and raised money, or you've met with VCs, at some point, a sophisticated buyer slash VC slash angel slash bank is going to ask, gosh, that's interesting, Rich. This looks like a fun game. They're going to ask some questions like this. What's your revenue? How many subscribers do you have? But at some point, they're going to ask this question, Rich. Do you own the code? Why? Brad asks non-rhetorically, why would they care that you own the code? And Gene and Rich, I don't know if this is going to be an interactive session or not. I'll just proceed rhetorically and assume that nobody's going to actually physically jump in and answer that. So why would the buyer ask, do you own the code? Isn't that obvious? Rich wrote it. Rich wrote that code. Rich owns that code. And so now extrapolate and multiply that by what? 10 million apps out there, all of whom are seeking an exit or in a round, right? Somebody's going to ask during that due diligence, because I always ask, and I do these deals all the time. I'm going to say, do you own the code? And you see how attractive it is to just say sort of glibly and rotely, oh, sure, I own the code. I wrote it. But as Rich has pointed out, he didn't write the code. An AI wrote the code, and he was lazy. Bless his heart. And because an AI wrote the code, here we go, no one owns the code.
Wait,
No one
what?
owns the code. Rich, were you going to say something?
Uh, just I want to make sure I heard you correctly. You said I own the code, right?
No, no, you wrote it, Rich, but you don't own it. The common misconception, the layman's perspective on this, when you're asked in due diligence who owns the code, unless you have a good lawyer like me, Rich, you're going to say incorrectly, well, I do because I wrote it. But AI changes that paradigm. And that's the point of our session today. AI changes that paradigm. So the more astute among you will be saying, well, Rich wrote some of it. There was some human, and the term we use in copyright law is authorship. So yeah, there was some human authorship. Sure. But was there enough human authorship to vest title to the copyright in Rich for purposes of selling it and making a warranty during that transaction that he owns the code sufficiently to give the buyer title? I think you all follow that. You're an astute group, right? The answer is no. So Rich doesn't own the code. There was some human authorship, but trust me, we've done this before. Not enough to vest title in Richard Hundhausen for purposes of an exit. It's just true. So, oh, there it is. Look at that. Hey, that's awesome, Rich. Good job. So during due diligence, when I ask Richard that question, who owns the code? If he answers truthfully, he's going to say, well, an AI wrote it. No one does. What's that going to do to the value proposition of the deal? Brad asks again, rhetorically. It's going to drive the deal value down. Rich has nothing to convey to me. Nothing. And in fact, I could, with complete legal impunity, get a copy of that code and copy it and compile it and run it as Brad's battleship and compete with Rich, and there would be nothing legally he could do about it because he doesn't own it. Contrast that with code written 20 years ago. Think of your favorite thing written by a human being 20 years ago. If we were to get a copy of that code and decompile it down to the source and copy that source code to create a competing product, we'd get sued all day long. We'd get sued all day long on that fact pattern. We own that code because a human being wrote it. The paradigm has changed, though, because of vibe coding and AI coding, and that model is no longer true for AI-generated code. And you might say, well, why is that, Brad? It's not Brad's position. That's the law. That's the current United States law. It's contained in promulgations from the Copyright Office, and it's contained in a federal circuit court decision that AI authored stuff has no intellectual property ownership constructs around it. It's just the law. Okay, now I'm going to go a little deeper here and talk a little bit about copyright law. But Gene and Rich, how do you want to handle? I see some questions floating in the chat. Do you want to pause for questions, Gene, or do you want me just to plow ahead?
Ray just responded. Brett, I'll be happy if you take them as they come. Since you don't have you don't have
Well, let's plow ahead, Gene, and I think we're going to stop at what, 11 o'clock Mountain Time in about 40
so
minutes.
budgeted, yeah.
Okay, why don't I stop a few minutes early then, or Rich and I can stop, and we can maybe go through the chat and pick some questions. Okay,
they're few already.
Okay, so Rich, let me pause. So far, so good. So Rich, you've come to me. You've said you want to have $1 million exit. I've said you can't because you don't own the code. And your reaction is what?
Well, I have a license to Copilot. I give them $20 a month. That's got to be worth something. Also, I wrote all those prompts, Brad. Come on, there's some human creativity here.
Right. Good. Those are good arguments. Okay, so let's go through that. Let's back up a step though and talk at a high level about copyright law. All right. Copyright law is one of the bodies of intellectual property law, along with patent, trademark, and trade secret. And copyright law is nice because the United States is a signatory to something called the Berne Convention, BERNE, as well as I think 137 other countries. So this is pretty much the law, what I'm about to tell you, in all of the Berne signatory countries. There are some outliers, but this is generally the law, okay? So let's begin with one of my favorite statements. I have t-shirts printed up, available in the merch part of the window here, that say copyright is a noun. Copyright is not a verb. Copyright is a noun. Okay. So we start there because many of you in your careers and in your life have heard this phrase. You need to copyright that. Hey, great code, Rich. Rich, you've written this great code. You need to copyright that. Well, after all these years, it no longer causes my head to explode like it used to, but it's just not right. You don't copyright something. Copyright is a noun. And specifically, when a human being takes a creative idea and reduces it into or onto a tangible medium, which is called fixation, a copyright, a noun is created. Period, full stop. You don't need to copyright anything, not in the United States. The moment you take a sufficiently creative idea and reduce it to a tangible medium, a copyright, a noun is created. And without more, you probably own that copyright. Now, if Rich had authored that battleship code as a human being, that construct would be true. That paradigm would be correct. A human being took an idea, battleship game, and reduced it to a tangible medium, source code in computer media, computer memory. A copyright has been created. But the wheels come off the bus because he used AI. And you're saying, but why? And the answer is because the law says so. The law says that content authored by an AI has no copyrightability and no patentability and no copyright and no intellectual property protections. So we come full circle to my earlier premise. Why then would I pay for it? Why would I pay $1 million for Rich's code when I can simply steal it and copy it and use it with complete legal impunity? He can't copyright it. He can't patent it. He has no ownership of that thing. And I will discover that during due diligence. It's just simply true. So copyright is a noun. To review, when you take a sufficiently creative idea and reduce it to a tangible medium, a copyright is created. So every single time one of you who is listening takes your phone and takes a picture, you have created a copyright, a noun. You don't copyright anything. When you write source code as a human being, you create a copyright. When you sculpt clay, you create a copyright. When you write a novel, you create copyright. When you make a movie, you create copyright. They're nouns. All of you own thousands of copyrights, probably, because copyright isn't a verb, right? So we get to that initial hurdle of when we're doing our due diligence by asking the question, did a human being author this thing? And if the answer is yes, then a copyright probably exists, and we continue our due diligence. If the answer is no, and AI wrote it, it was vibe coded, or Rich, we did what Rich just did, then the answer is no, nobody owns it. So I know from having done this before, and Rich asks a good question. So let's consider some of your unasked questions. What about that prompt? Wasn't that prompt sufficiently creative to merit the output copyrightable subject matter? No. And if you have to imbue a prompt with sufficient creativity to make it copyrightable subject matter, then what's the point of using an AI, right? Where's the time save? If you've got to write a 15-page prompt to generate what would have been 17 lines of source code. You see what I mean? 17 pages of source code, right? So there is no time saving. So let's review. 1, copyright's a noun. 2, no copyrights in AI authored content. 3, thus no value proposition, because you cannot create, another one of my favorite expressions, a lawful monopoly in something which you do not own, and no one will pay you for it. Now, I agree that if there is some rube out there who will sign a contract that says, oh yeah, I'll give Rich money for this, to access to this object code and run Battleship on my browser. Sure, I will. But see, that's contract law. That's different. And if you can get some rube to sign your license agreement and agree that you have a copyright in the thing that you don't, well, good for you. But I'm not that guy. I'm certainly not going to sign. In fact, every deal I do now, every single deal I do, whether it's an inbound or a software license or an IT consulting agreement or an NDA, every single one now contemplates the impact of AI. Mm-hmm. I'm not going to sign why would I let a client sign a license agreement to code when we have discovered during due diligence during that contract process that the code was written by an AI? Why would I contractually, see what I mean? Why would I contractually elevate that vendor's rights to something that don't exist by signing a contract? I wouldn't. I just wouldn't do it, and I'm not going to.
Pause there for a moment. How many thousands of consulting companies, contractors, big ones like Accenture and the big five are, being paid by clients to generate code that on their desktop, they're doing what I did.
Right.
This is a house of cards.
Well, it is. And so this is why, Rich, now every time one of my clients engages a coder as an independent contractor, I put a warranty in there that says, vendor, coder, contractor hereby represents and warrants that all of the deliverables will be human authored and not generated by an AI. Would you have thought to look for that in a contract 10 minutes ago? Maybe, maybe not. But that's been in my contracts for the last 3 years because I want my clients to own those deliverables so that they can what? So that they can go out and monetize them. It's all about money. Intellectual property is about money. Intellectual property, Gene, prints money. If you haven't thought about it, think about it that way. Intellectual property prints money because we're taking this amorphous, intangible thing, an idea out of Doug Levitt's big brain, and we're turning it into money by encapsulating it in intellectual property. And we're giving Doug Levitt a lawful monopoly, and he can sue people to make them stop using his thing and sue people to make money off of that thing. Without that, Doug Levitt cannot, nor can James Carpenter or Malcolm Sturgio or Isaac L. You can't unless you have a lawful monopoly, and you don't have a lawful monopoly, kids, unless you own the IP, period, full stop. And if it's an AI that wrote it, there's no IP to own. So where's the value proposition in vibe coding? Where is it? I don't see it. Rich?
Ralph asked a good question, which
Okay,
is,
Ralph, go ahead.
I know I can't sell Battleship. I can't sell my company. The due diligence will find there's very little value in code that I don't own. But can I still charge people $10 a month to play the game?
Sure. And that's the point I made earlier. If you can get somebody to sign a contract and agree to pay you money to use your thing when you have no legal right outside of contract law, sure you can. Sure you can.
Because people don't play code, they play games.
Right.
They don't have any idea.
At the end of the day, though, Rich, if somebody reverse engineers down and downloads that code and reverse engineers it and creates a competing product, you have no recourse. Unless your contract, the license says, thou shalt not access my server and download the code and decompile it and compete with me. Well, if your contract is that robust and somebody actually signs it, good for you. I would never sign a contract like that. Right?
Nice.
So it's all about building this lawful monopoly. And my perspective as an intellectual property lawyer is from day one, as we say in the Latin, ab initio. Come on, I'm a lawyer. I got to throw some Latin in here.
Yeah,
Ab initio, from the beginning, your goal as entrepreneurs and coders, assuming this is your thing, maybe you just want to be a contractor and write code for, $100 an hour. Great. But if you want to be an entrepreneur and stand up something that you can sell, my respectful suggestion is that you contemplate these issues and use AI with great discretion, because no matter what you do, it's very, very difficult to take AI product and turn it into something in which you can have a lawful monopoly, because the law says so. Okay, so let me pause there. Let's look in the chat. There's 11 questions in the chat. Maybe we take just a second here and look through some of those. Rich, are you in the chat? Are there any questions?
Yep, I can proctor these.
Thank you.
So let's see.
Go ahead, Rich. Let's take a question out of chat, then I'll talk about a separate issue here.
Okay, so Doug asked, is it about who originates the code? What if Rich updated the code after it was originated? And Doug,
very good, Doug. Very good. And it depends on who the original author is. So let's talk just a little bit more about some copyright law specifics. Somebody saw something in there in the chat about derivative works. Okay, so we always begin from the premise that we have a human being who made something creative and put it in a tangible medium. Everything starts there. Whenever a client calls me with a copyright question, what's the first question I ask? Who owns the copyright? Everything flows from that. You see how everything now flows from that? Who owns the copyright? And I ask, did a human being write it? And is it creative? Isn't it tangible? I go through those tests, right? And ultimately we conclude that yes, a human being authored some copyrightable stuff. We start there. Now, if Rich has created something which is copyrightable subject matter, human authored source code, and he gives Doug Levitt a copy, and Doug changes that source code, Doug may have created what's called a derivative work. A derivative work starts with original copyrightable subject matter and changes it in a certain fashion. Now, Doug, there is this continuum in copyright law. Bear with me, it's going to get a little bumpy here. There's a continuum in copyright law. We start with Richard's original work. If Doug makes a derivative work without Richard's permission, that's copyright infringement. Richard will sue you and win. However, Doug can go beyond the threshold of creating a mere derivative work and add, are you ready? Sufficient new human authorship to that original work and create his wholly new original uninfringing non-derivative work. So you might ask, well, where's that line? Where does it stop being a mere derivative work, which is infringing, and a wholly new work that Doug owns the copyright to? Don't know, Doug. Let's go to court and find out. That's literally, I don't mean to be glib or flippant. although I am. That's that's how you find out, right? Rich sues you, and you go to court, and your lawyers say, "No, no, judge," and 12 men and women, good and true of the jury, "No, no, this isn't a mere derivative work that I needed Doug Richards' permission to make. This is a wholly new work of authorship, and I own the copyright because I'm a human, and it's not a mere derivative work." There you go. What's else? Anything else look good in the chat, Doug? We're Rich.
So follow up to that, Brad, that we're kind of in an unknown situation right now. There's the copyright law is still based in what, from the 1970s or something, and there's not been any really good legal cases decided one way or
Right.
the other. And
Well, it's a good point, Rich. Let me just jump in and tell you how did we get here? 30 years ago, this was with this conversation, 20 years ago, 15, 10 years ago, this conversation wouldn't have happened, probably, right? Because there wasn't a lot of machine authored stuff. And so people at this point always go, well, what about music created by a synthesizer? What about Moog music? Isn't that no copyright in that? What about the output of an Excel spreadsheet? What about that, Brad? Isn't that AI generated? And the answer, no, that's a false analogy. Those tools, like a Moog synthesizer and a spreadsheet, there is still a one-to-one correspondence between human inputs and machine outputs, generally speaking. So when I have a machine transcribe something, well, isn't that AI? You don't own a copyright in that transcript. Sure, I do, because there is a one-to-one correspondence literally between the words coming out of my mouth and the machine dictated transcript. But the AI pretends this faux creational task that alters that one-to-one correspondence, and that's when we no longer have authorship. You see the difference? So here's how we got there. Over the years, people went to the Copyright Office and tried to, and I need to explain this. Let me back up one step. Okay. You now all hopefully know how you create a copyright. A human being reduces a sufficiently creative idea into or onto a tangible medium. Great. Somebody takes it and makes a copy or a derivative work or other things. That's copyright infringement. If you own a copyright, you can sue them and make them pay. Hey, monetization. Remember that? Monetization. Sue them and make them pay. Great. The law changed in 2019, however, to say that you can't sue someone to make them stop and pay you, Doug Levitt, unless you have what's called a registered copyright. And that means that you literally take your source code, assuming you own it, right? And you haven't given it away by virtue of what's called the work for hire doctrine or some contract. If you actually own that copyright, then you, the human being, go to the Copyright Office and pay, are you ready? $75 and register the copyright in the source code. And you get back a document called a copyright registration certificate. Now that's what you need to go to court. That's, as we say back in the old days, anybody remember, old enough to remember e-tickets at Disneyland? That's the e-ticket that gets you into court, is a copyright registration certificate. Okay, once you have all that, then you go file a copyright infringement lawsuit. Okay, now over the years, people went to the Copyright Office, including this guy named Stephen Taylor, Thaler, and said, hey, Copyright Office, I want to sue this guy. And to do that, I need a copyright registration certificate. Copyright Office looked at his thing that he sent in and said, hey, Stephen Taylor, did a machine author any of this? Is this machine code or is this human authorship? And Stephen Taylor honestly and truthfully said, no, there is machine authorship in here. And the Copyright Office rejected his application. They said, no copyright registration for you, Stephen Taylor. And now Stephen Taylor can't go sue anybody. You see the problem with my lawful monopoly if you can't go sue him to make him stop? And a condition precedent to being able to sue them is that registration certificate, and you can't get one if the Copyright Office sniffs you out, smells AI in there, and says no copyright registration for you. Isn't that interesting? Right? So you may purportedly own a copyright, but it's toothless. It's meaningless unless you can go sue and make them stop, and you can't without a registration certificate, and you can't get that unless, well, you either lie to the Copyright Office, which is bad because that's perjury, or you have sufficient human authorship to merit having a copyright registration. Now we can go sue them. So that's how we got there. Over the years, people have done what we'll call these test cases and said, hey, I want to register this copyright. The Copyright Office says no copyright for you. Or you lie to the Copyright Office, you get a registration, you go sue somebody, and in that lawsuit, you get found out. See? So over the years, these things have evolved to teach that, okay, no copyright or patentability or IP ownership for AI authored or invented stuff. Prompt doesn't matter. Prompt doesn't help you. And somebody asked correctly, machine as opposed to tool. Yeah, these are all good questions. Okay, let me pause there. Rich, what's in the chat that looks interesting to you?
uh, well, let's see. I'm going to jump to Todd Shelton. Hey, Todd. Todd and I are friends going way back. Uh, you jumped a few questions. Do you want to just unmute Todd? Are you able to do that and throw out a primary question?
I can flip into the chat too and just scroll through them. I just don't want to give anybody short shrift here.
Yeah,
Oh, there's a lot of Go
I
ahead.
was pretty verbose, which Richard knows is kind of me. But I think this is a super interesting topic. I think I had three questions. Number three, what is human authorship? And then followed up because Brad, you'd said 1-to-1 came
Yeah.
out, and uh, and then with the Taylor case, machine as opposed to tool, where do the guardrails have to be? And ultimately, what I'm interested in is if you go do a due diligence with a company that is using AI to develop software, what what do you have to see besides the blanket, warranties and reps to say, oh yeah, this is cool. There's an actual copyright here, and I can go ahead and advise my client to buy it.
It's a good question. And the answer, I now ask for copyright registration certificates and deposit copies. That's a very specific legal thing. So if I'm going to go buy a software company or invest in a software company, and my clients do that all the time, now in due diligence, I just don't have them rep and warrant that they own that copyright because that's not sufficient. I say, oh, so you want us to buy a copyright because that's what you buy, right? When you buy a
Right,
software
right.
company, what are you buying? You're buying copyrights,
Hmm.
right? I say, show me the copyright registration certificates and the deposit copy. The deposit copy is that thing that you send into the Copyright Office that creates, as we say, the metes and bounds of the copyright registration, just like in real property law. You know what a deed is, right? The deed has a legal description that describes the metes and bounds of the property. And if you step across that line, those metes and bounds, you've committed what's called trespass. Copyright law is kind of the same, right? So you send in a copyright registration application and a copy of the thing, the photo, the clay, the source code, whatever, right? That's called the deposit copy. So now in diligence, I ask for a registration certificate and the deposit copy. And then under NDA, what do? Under NDA, I say, okay, show me your source code. And I compare it with the deposit copy. And if they're not the same, we don't have a deal because they don't have a copyright in that thing. Does that make sense? That's exactly how you do it.
Yeah, it does. It makes perfect sense. That puts the burden on the Copyright Office to say whether there's a actual copyright or not.
Right. And and you know what, we can continue the hypothetical and we can assume that the seller has title and then we can go out and try to monetize that IP, what? By suing somebody to make them stop. Doug Levitt,
Right.
my favorite new plaintiff. We're going to go sue him to make him stop, right? Get that lawful monopoly. In court, we'll find out there's no copyright. I'd rather do it during due diligence
Yeah.
and have the buyer prove to me that the Copyright Office has already asserted or demonstrated, or at least the legal term is this: a registration certificate is prima facie evidence, more Latin, prima facie evidence of a valid copyright. Does that mean you're going to win in court? No, it's prima facie evidence. But in court, we'll still blow it apart, right? If I'm the defendant's lawyers, I'll dig deep and I'll find out that you don't have a copyright in that thing. See what I mean? So the
Yeah.
copy, and that's why I was kind of upset when everybody on LinkedIn, all the AI fanboys just went nuts when the Copyright Office put out these three rulemakings that talked about, AI and copyright. And they said some AI content can be copyrightable as long as there's sufficient human authorship. And everybody was going, oh, Brad was wrong. Look what the Copyright Office said. And I had to sit on my hands for 10 minutes. And then I very calmly typed into the LinkedIn chat, I said, copyrightability is not determined by the Copyright Office. It's determined by federal courts after Doug Levitt sues somebody for copyright infringement. See, so everybody freaked out when the Copyright Office said, oh, AI outputs are copyrightable. Untrue, completely untrue. If anybody tells you that, and if a lawyer tells you that, say you're wrong. Copyrightability is not determined by the Copyright Office, as funny as that sounds, it's determined by federal courts. And that is why, during due diligence, having a registration certificate and a deposit copy is great, but it's not the end all be all. See what I mean? Because we haven't
Yeah.
tested it. We haven't tested
Yeah.
it in federal court yet.
Yeah, not to monopolize the conversation here, and I'll get out of it here in a second, but I have a follow-up question, which is in software development, let's say, let's pick on Rich's game. So he puts a deposit copy of he manages to convince the PTO that's legit thing. He puts his deposit copy in there. You go to buy the game, but and this is probably not specific to software development, but it's very common
Right.
since that when you do the code the code examination under NDA, it's different because the thing's moved on. just organically. How do you align that, or do you make a judgment call, or because it seems like
Sure.
do we have to post repost to the copyright office? That's the
Well,
ridiculous.
Todd, no, let me, no, sure. It's a great question. Here's this very specific answer. Okay. Soft coders and everybody else in the world today are at their core media companies. Think about it, right? You're a media company because you generate code or whatever you do. You're an influencer, whatever you are, you're a media company. In 2026, everybody's a media company. Okay. Well, in the old days, companies protected their assets with fences and guard dogs and stuff, right? Now, media companies protect their intellectual property assets how? With patent applications and copyright registration applications and trademark registrations. That's how you do it. That's the fence, the dog, and the watchman in 2025 is IP. Okay. So a media company, just like you every night, I hope, Todd, brush your teeth, a media company registers its copyrights. It's $75. You do it once a month, or every time there's a new rev of the code, or every time there's a new iteration, you just spend $75 and send it into the new code base. See what I mean? So to me, to have a buyer go, oh, well, the code's different now, I would say, man, you got bad legal advice. Aren't you brushing your teeth? You're a media company. You should be registering your copyright in every rev of the code because it's $75. And if you do it smart, there are ways to do what are called group registrations. And you can do 10, 15, 100 different deposit copies at one time with one $75 fee, Todd, using what's called a group registration. So I got no better answer for you other than, hey, not my problem. You should have been registering copyright so that the thing that I buy has a current registered copyright. It's kind of no excuse. Gosh, I've made the group silent. Rich,
So
go to the chat. What do we got here, buddy?
So you sparked again an idea for me. I just had to look up if the Copyright Office has an API, so I could build a GitHub action that would automatically, submit my code every time a build comes out of master or main.
Right. It's great.
And just hook up your credit card and just every build, 65, $75. James has a couple good questions, as I expected. If James trains his AI on other code that he does own, like a private repo or a series of private repos, I'm guessing, right, James? Then now, what about that?
Right. So what are we trying to do with that code output? I don't know. Are we trying to out-license it? Are we trying to sell it? Are we going to court to sue somebody? It kind of matters because
So I'm thinking if you were a Microsoft or a Google and you had an existing large code base,
right.
and you could say, we'll simply train our own in-house on AI entirely on our own stuff, and we have enough body of it that it will be a useful tool when we're done. Then can we use that, and will that generated code be considered?
Yeah. Let's go to court. Let's go to court, James. Let's go to court and hire an expert witness and find out.
So there's no precedent for that yet.
There is not. Although I can bet you, James, I'll bet you lunch that we will determine that those outputs from that AI that we're using an LLM that were trained on your pre-existing stuff, there will not be a copyright in that because the LLM has done enough machine transformation. Even though the original inputs, the training data were owned by you and it's copyrightable subject matter, you have now transmogrified them enough using the LLM that those outputs probably will not be considered human authorship in court. That's my best guess, frankly.
And so a related question I had is, so I'm thinking, from a business perspective, if you're a CEO, how do you manage this? One of the things you would do, obviously, as you already mentioned, is when you contract with someone, you would have relevant clauses that would forbid the use of AI generated code. If you're contracting with some offshore company, even onshore, well, the truth is they're going to do it anyway and claim they didn't. And I'm supposing that you just have some sort of indemnification and errors and omissions type insurance or whatever relevant insurance that will pay off when it's found out that they did use AI and then you did get sued on it, and then and they'll collapse their legal entity will go poof and they'll make a new one, and
Sure.
the insurance company will be upset. I'm guessing that's what happens in practice.
Well, no, and the reason is because offshore companies don't have they don't want to offer indemnification because they're offshore. Why would an Indian coder give you indemnification? Even if they did, it means nothing. because you can't practically collect against an Indian company. If they have
Yeah, yeah, that's right.
if they have a U.S. presence and they have a brick and mortar building here and $1 million in the bank and Chase Manhattan Bank or something, then maybe I can get indemnification. But as a practical matter, indemnification from an offshore company is worthless. That's why I tell my clients not to use offshore coders. Rich, did you
It's
have a
also
question?
worthless from a small, tiny LLC like myself or Richard. I mean, like, what are
Yeah.
you going to do?
Well, that's
Unless you
kind
can
of true,
pierce the veil,
James. I
maybe.
mean, it's kind of true, right? I mean, you, James, is a small company. You can indemnify to the moon because if they sue you, you just go bankrupt. Frankly, I mean,
Right.
no
Yeah.
kidding, right? Rich,
Quick
go ahead.
question, Brad.
Yeah,
Is India part of the Berne Convention?
they are, but it's a different issue, right? I
Yeah,
mean, you
sure.
can have a copyright in India using U.S. law, but that's very, very different than a coder indemnifying you because you're getting sued in the United States because you breached a rep and a warranty and a sales contract, you
Gotcha.
know? So
So,
let's see.
so,
Go ahead. Go
so
ahead.
this topic is toxic enough, or toxic to the potential uh, wealth management of all these very large software companies. Um, I'm assuming that I mean, there's got to be a lot of proposals to change the law on this, both within the U.S. and outside of the U.S. And I don't understand what happens if it changes in Europe. How does that translate back here because of the Berne Convention, et cetera? So, what do you anticipate happening here? Do you think we're kind of in a is it settled down and this is just the way it is? I mean, obviously the way it is now, or do you think, within a year it'll be different kind of thing?
Right. So my prediction is this. We're looking at throwing out 500 years of copyright law and a constitutional clause. Constitution, US Constitution created copyrights, right? We're looking
Hmm.
at throwing all that out just so Sam Altman can have a double espresso in the morning, right? Not going to happen. It's not going to happen. So the law is not going to change anytime soon to reward the Sam Altmans and the Twitter guy and the Sergey Brins, and it's just not going to happen. I know that because think of what would the consequences be to the economy? Think about Disney. Think about Pixar. Think about Pixar, right? Think about your little daughter at home watching Frozen and singing along. Let it go, let it go, let it go, right? What happens if we suddenly say, oh, all of that's in the public domain? There is no protection for AI. There is no copyright anymore. You will suddenly devalue a $1 trillion economy, right? So that's why it's not going to change anytime soon. What will happen is this. Companies like Microsoft, OpenAI, and Grok and Anthropic, they will, one, on the input side, they'll start paying to license data sets. They'll pay. Can't just go out and scrape the internet for free anymore because that's copyright infringement and that's the law today. Did you know that? It's illegal to go out and scrape to train. It's not fair use. Bratz didn't hold that. Anthropic didn't hold that. Meta didn't hold that. None of those cases held that. And all the fanboys are screaming, oh, it's a fair use now. It's not. So one, on the input side, scraping to train is still copyright infringement. Okay, number one. That
So
won't
now
change.
we're back to my question, my original earlier question. Yeah.
Right.
Right.
And that's not going to change, James. What will happen is they'll have to start paying for inputs like a cost of goods sold,
Sure, sure.
just like a movie company pays a cameraman to stand there and spin the reels, you know? Okay, same thing. Okay, that's the input side. On the output side, what they're going to have to do is people will simply have to, now it becomes an issue of risk tolerance, James. How much risk are you willing to bear knowing that you cannot create Doug Levitt's lawful monopoly in these outputs? Do you care? I get a lot of people saying to me, who cares? Brad, who cares? This is a nice academic discussion, but who cares? And you know what, Doug or James? Maybe that's the answer. Nobody cares. So what will happen is we'll build this economy, this $1 trillion AI economy, and then what will happen is when somebody goes to court, the U.S. Supreme Court will finally say, no, no, there's no copyright here. The Supreme Court, U.S. Supreme Court hasn't held that yet. And suddenly everybody will go, holy cow, Mickey Mouse is in the public domain. Let's go print Mickey Mouse t-shirts for free. And everybody in the world who has spun up an AI thing suddenly has no valuation model. It's the Wild West. It's anarchy. Well,
But
stealing
the
is
banks won't care, and the people that are providing a service, the electric company, we all know that they all think their code is unique, but
right.
it's just the same as everybody else's. And the truth is, if their code got leaked, it wouldn't be the end of the world because their real value is not about their code. It's about some other aspect of
Right,
the
James,
business.
and you're saying what a guy said to me once after one of my presentations, and he came up to me and he said, "What if you don't care about IP? What if you don't care about IP?" So great, then I have nothing to say to you. Good for you, right? You don't want to have a lawful monopoly. Bless your heart. I don't care, right? I don't. But that really is the issue, James, is if you don't want to have a lawful monopoly, great, right? And to your point, what about banks? You mentioned banks, maybe that was just a Freudian slip.
Yeah,
Banks,
just yeah.
banks care because they're loaning millions and billions of dollars securitized by air, by vaporware, right?
Oh,
Think
no,
of
no, they do from a loan management perspective, but
yeah.
in terms of running their retail banking,
Oh, yeah, they don't care.
they're just
You're
for
right. They're not there, but that's different. They're not out monetizing. They're not selling Rich's battleship game on the App Store. That's very, very different, right?
yes, the solution is to monetize something other than uh, if you're in a situation where you monetize
Sure,
something other than your code,
agreed. And
is the real value.
you're in an environment, James, where you don't care if somebody, a former disgruntled employee, leaves with your entire source code base and takes it to a competitor. And if you don't care about that, great.
You care about it from a tax, from a perspective of security, but you don't really care about it in terms of IP because
Fair.
your walls are, you do care about people being able to hack you because they know more. But
Right. So, I mean, it's a good discussion, James, and you are right. If there is a company that doesn't care about IP and a lawful monopoly and monetizing an asset, an IP asset, and it's just part of their infrastructure, then who cares? Use it, you vibe code all day long. But remember that if somebody does hack your server and take that code, or a disgruntled employee leaves
they can
with
run
a
it.
two
Yeah.
terabyte flash
Yeah.
drive, you have no recourse against that competitor. So when you call your lawyer and go, "Hey, that bank has now replicated my functionality for my direct deposit modality," it's exactly the same. And I'll say, "I'm sorry, there's nothing I can do to help you because you didn't treat your code as IP. Sorry, good luck."
Yeah.
So what Brad is saying here is AI should only be used for open source projects or public domain, taxpayer funded government projects that don't really care about IP in the first place.
Not untrue, Rich. If you don't care about IP, then use AI all day long. But I have a very hard time finding a scenario in which you don't care about IP.
Exactly.
I just don't. Well, we're about out of time here, Gene. I think we have questions in the queue.
Yeah,
You can either print those and email them to me, or we can have another session or whatever you guys, or hey, anybody who's on this call. I mean, I'm not in this to make money. If you guys want to reach out and email me or chat me or text me or DM me on LinkedIn, I'll talk to you for free. I think this is a fascinating topic.
I was just gonna say I don't want to be a conduit for this unless you want me to, Brad. People have eyeballed your name, your first and last name enough to know who you are and where to find you. And if you are kind enough to take their calls or emails,
Sure.
whatever comes out of it, by all means, if people choose to reach out to me, I'll just direct them to you.
Please
Yeah.
do, Gene. Please do. Because to me, this is just a fascinating academic
I
exercise,
believe
right?
so.
Yeah.
In fact, my question was also there lingering. I'll may ping you separately, but mine is not about the IP. It's about how to give it out for free. Anyway, silly enough. Folks, we have one more minute, and I think we'll just maybe wrap it up as opposed to how about we do this? We're gonna wrap this up because we need to make sure that Brad and Richard go on with their lives. It's Friday. Please make a note of their contact information and reach out if you have any questions.
Right.
I want to thank you
Rich,
both.
Did you have a
Brad.
parting comment there, Rich? I saw your hand go up, Rich. I just
Just
want to.
I dropped a link into our whoownsthecode.com website.
Yeah.
It's just getting started, but it's got a recap of a lot of what we mentioned here, how to contact us, and there's even an assessment on there that Brad and I are, still working on. It's kind of an MVP right now, but answer some questions and see how at risk you are.
Hey, I'm glad you guys like this. I appreciate all the nice comments in the chat. Seriously, thank you guys. And don't be shy about
Absolutely.
reaching out, right? I mean, I'm happy to talk. I think it's fun. I think it's interesting stuff.
I certainly will pave the road for that, and I hopefully the recording that I'm doing in the background will work out without any hiccups. So there'll be more content to share. Thank you very much, Brad, to you personally for sharing your wisdom, to Richard for making this introduction and making this also happen. And
You're welcome.
All the best to everyone. Have a good the rest of Friday and great weekend.
Thanks
Thanks,
a lot.
everybody. We'll see you guys later. Take
Thank
care.
you all.
Thanks.
Cheers.
Bye.
Bye.
Todd, good seeing you.